Okay, I think we'll make a start there. So good morning, everyone, and welcome to our second webinar on the employment law changes that we are getting to grips with this year. I'm Ed Hussey, and I'm here this morning with the rest of our client HR services team, being Karen Gibb, Chris Miles, and Sandra Sue. And we're delighted to be joined by Andrea Tischler this morning, who's a solicitor, employment specialist, and director at GBH Law. We're focusing on holidays this morning, which has become a surprisingly legally technical topic over the years, particularly around workers with variable hours. And so we're pleased to have Andrea on hand to deal with the difficult questions. Thanks, Andrea. Before we go there, though, let me just say that this is a live session. It's being recorded, and we'll send you a link to it and a copy of the slides afterwards. Our previous session on changes to family leave can already be found in our employers community or on our website, and we'll point you there later on. We're going to structure today as a Q&A session to try and cover everything that you've asked us in advance, and we will answer as many questions as we can as we go through the session. So please put your questions in the Q&A box, which I hope you can find on your screen, and Sandra will manage those questions, and we'll stop at various points and see what questions we've got. If we're overwhelmed with questions, we'll deal with them either at the end or after the session. So we'll make sure we get to all of them one way or another. And just on questions, please don't be shy. We all scratch our heads on this subject a lot, all of the time, even when we're dealing with it regularly. So please don't feel that you're being foolish if it's not sinking in, because it does take a while, believe me. So let's have a quick look at the agenda for this morning. We're going to have a very brief recap on the other changes that are happening this year, lest we forget, but we are dealing with those in more detail at other times. Our main focus will therefore be on the holidays and holiday pay situation, and we'll be explaining the changes, their impact, and practical steps that you can take. And then we'll deal with any questions that remain at the end. And we've got a little poll to finish off with just to see how you're feeling and whether there's anything that you'd like us to follow up on afterwards. Let's start off then with a very quick recap on the changes overall in 2024. The ones in blue we're basically dealing with today. So simplified holiday pay and carryover. Treat the word simplified with a bit of a pinch of salt. Don't get too excited about that. In March, the delayed holidays from COVID. You might remember during COVID, you were given extra time to carry over holiday leave. Well, to carry over leave, and that all came to an end at the end of March. And then from April, we had the national living wage applying from age 21. So the higher rate applying a bit earlier for people. So that was something that was important not to miss. More holiday changes, which we'll come to. And then there were a number of things around family leave. So new carers leave was introduced, changes to the flexible working request regime, and there are also changes to statutory paternity leave and to the redundancy protection that's given to pregnant employees, those on maternity leave, shared parental leave, and adoption leave. And those are all dealt with in the session we did last week and available online if you'd like to know more. Later in the year, we have in July, well, not in July, so due in July were the new rules on the distribution of tips, which 1 week ago exactly was delayed until the 1st of October. We'll be coming back to that. And some TUPE changes, transfer of undertakings for smaller companies, which actually will make it easier if you are a smaller company, but we will come back to those later in the year and explain more about them, as we will with the new right to request predictable hours and the new duty to prevent sexual harassment, which we're expecting to come along in the autumn, but we will return to those. Finally, there were some immigration changes. So for those of you who are licensed sponsors of people on visas, these were obviously important. Certainly numbers 1 and 3 were very important, and I'm sure you've probably caught up with them already. And if not, then please do so. In terms of number 2, the fines went up for employing illegal workers, and so our plea there is to please make sure that you are properly checking everyone's right to work when they begin their employment with you. And if you've got any questions about that, do let us know. So that's the extent of the general roundup, because we've got a lot to cover on the subject of holidays. So I'm going to start by asking Karen, what are these changes that we need to explain today?
Okay, thanks, Ed. Good morning, everybody. So the changes we're going to talk through, those of you who have been working in this field for a while, some of these will be a welcome return. So they won't feel entirely new, but essentially they're a reintroduction, and in some cases quite a welcome one as well. So the first thing you might recognise is the reintroduction of the use of the 12.07% calculation. And that's particularly for irregular hours and part-year workers. We also have the reintroduction of rolled-up holiday pay. Once again, that's a return, something that used to happen, and that's also being brought in for irregular hours and part-year workers, which will be very helpful for some of you. Usefully in the new legislation, we now have a very clear definition of what should be included in a week's pay when you are making your holiday pay calculations. That tends to have been the legal minefield over the last few years, and actually continues to, and up to this day, to be something that is still debated and changeable. But at this point, we do have a definition of that, which we'll show you later. And we have some changes to the carryover holiday rules. When we come back to those at the end, you'll find some of those are very familiar, but we've got a couple of points there that it's well worth taking into account in managing your holiday through the year. Now, all of those changes were effective from the 1st of April onwards.
Okay, thanks, Karen. I'd like to bring in Andrea now. So Andrea, welcome. Thanks for joining us today. We're really grateful. The first couple of points that we're dealing with on that list there that Karen told us about are to do with irregular hours and part-year workers, so people on variable contracts. And so perhaps a good place to start is, what is actually the definition of those workers, because they are going to be the topic of our first couple of sessions.
Morning, everybody. So we do have in the regulations a definition of the term of irregular hours workers and part-year workers. And irregular hours, as it says, those whose hours are irregular. So we're talking about casual workers, agency workers, those on 0 hours contracts, bank workers such as catering staff. So it actually picks up an awful lot of people, and it's really the whole point of these regulations is to give us some clarity. Those of us working in the employment law field have had an awful lot of changes around this area, and as a consequence, there's been a need to look at contracts and revisit how pay is dealt with. The other element, obviously, is part-year workers. So those, we're looking at people whose contracts include periods of at least a week in the year when they don't work and are not paid. So you're looking at, it comes up a lot in the schools world in terms of term time workers, comes up in higher education, people who do marking, people who do summer duties, take on over the summer holidays. So that's picked up by part-year workers.
Okay, thank you very much. And so what we're going to look at first is calculating holiday entitlements. So we're going to be quite clear about splitting this out. The first thing we're going to do is look at how do you calculate an entitlement to a number of hours or days off, and then we're going to move on to look at what do you pay for that holiday leave. So we're going to start off with calculating the entitlements. And as Karen mentioned, we've seen the reintroduction of this 12.07% calculation. So let's look, Andrew, if we could first of all, at what does that actually mean, and a couple of examples.
Sorry, so I will unmute. So we've got the return of the 12.07%. So for those of you who remember, this was something that we used to use quite a lot, and then it was held that we couldn't be rolling up holiday pay and we couldn't use this percentage, and it's back again. So what we're talking about here is how the way in which this percentage came about is because we have an entitlement to a statutory minimum holiday period of 5.6 weeks per annum. So in terms of looking at where this percentage is, you've got your 5.6 weeks entitlement. If that's divided by 52 weeks of the year, less the 5.6 weeks, which is obviously the number of working weeks in the year, less the 5.6 weeks entitlement, that gives you 12.07%. So the entitlement is the hours worked times 12.07%. That gives you a percentage for you to actually work out what the element of pay to be added on that relates to their holiday entitlement actually is.
Okay, so let's try to bring this to life a bit more then with a couple of examples, if that's okay.
Yeah, so the first example is a part-year worker. So we're looking at somebody who is a term time worker. They work 34 weeks in the year. So there obviously are a number of weeks of the year in which they don't work. So what we've seen already is that percentage. So they are accruing their holiday at 12.07% of the hours that they are actually working. So if you were assuming that this individual works 8 hours a day, 5 days a week over 34 weeks of the year, that gives you 1,360 working hours. So all we need to do, therefore, to get the holiday hours is to times 1,360 by 12.07%. And then we get a lovely 164.52 hours worth of holiday entitlement. So as you can see, that 12.07% makes it nice and easy for you to work out their holiday hours, and you know what their entitlement is for the holiday year.
Okay.
So that's
Shall
our
we move on?
Worker.
Mm-hmm.
So we've got a slightly different example for you. It's another school one, I'm afraid, but it's we've got Fred in a maintenance department. So he's got variable hours over the working week. So he's got 6 hours working on a Monday and a Tuesday, and 3 hours on a Wednesday, Thursday, and Friday. So a full-time employee who works in the same department has an entitlement to 28 days annual leave. So obviously, how much leave is he actually accruing? He's got these uneven working hours during the week. So you're going to need to calculate his holiday entitlement in by looking at his average working day. So the average length of his working day, you're taking 21 hours over the course of the week, 6 hours Monday, Tuesday, 3 hours Wednesday, Thursday, Friday. So 21 hours in his working week divided by 5 days a week. So his average is 4.2 hours a day. And then to get his annual leave, all you're doing is saying 28 days entitlement times 4.2 gives you 117.6, or we do a rounding up kindly. So it's 118 hours per year. So that gives you his hours per year of holiday entitlement.
Okay, Andrea, thank you for those. I'm going to just pause there because we're going to move on and talk about pay, how holiday pay. So, Sandra, are there any questions yet around this, or is everyone either clear or stunned into silence?
Good morning, everyone. We do have a question. So the question is, are bank holidays included in the holiday hour calculation / allowance?
Very good question.
So it might be better to hold this one until we get later into the presentation. The reason being is I think, Ed, we're going to be touching on the 2 ways of dealing with holiday pay, and I think that will help in relation to what we're looking at here. But you've obviously got statutory, just to say as a general comment, you've obviously got statutory entitlement of 5.6 weeks, and that's your starting point as to what the holiday entitlement is. Query, you know, what does the contract say in terms of including or not including bank holidays? So you may actually have an individual who has a contractual holiday entitlement that's greater than the 5.6 weeks. The calculations that we're looking at here are obviously based on the fact that that person has 5.6 weeks. So that's what you're saying. It's 5.6 weeks. You're not adding on any additional bank holidays to that. And that's how we run these calculations.
Okay, so thanks for the question. It's a really good one, and we'll touch on it again, as Andrea says, a little bit later. So the next thing we're going to do is look at how you calculate holiday pay. So you've worked out an entitlement, and now you need to think about what you're going to pay. And Chris we're going to bring you in here, because there are effectively now two methods available, aren't there? So can you just touch on those?
Yeah, sure. Morning, everyone. Thanks, Ed. Yes, there's essentially a choice now of how you want to work this out, or the two systems there are for holiday pay. So as you can see, there's the two key ones are, it's either choose to pay your workers for the annual leave at the time they take it, or pay an uplift instead and roll this up with their pay in each pay packet. You just need to decide which is easier for the business, and importantly, apply that policy consistently. You need to make sure that your employees take the time off work regardless of how you pay, minimum of 20 days per year. It's worth remembering all workers should take this, or the pro rata equivalent if they're part-time, because, you know, as we all know, well-rested employees will be more productive, they produce higher quality work and have less sickness absence, all of which are obviously a benefit to your business. So it's really important to remember. So yeah, and this applies from holiday years from the 1st of April. So you either pay as you go or roll it up.
Thanks, Chris. So just on the rolling up, let's just have a slightly more detailed look at that, since it's the thing that's being brought back in. So let's just talk about that. And then I think there's probably a few questions for clarification that might pop up.
Yeah, sure. So yeah, rolled up holiday pay. So this is when an employer spreads holiday pay over the year by adding an amount on top of someone's normal pay. So it's instead of paying for someone for holiday when they take it. Those who work part of the year will naturally get a break during the periods they aren't working, and those who work irregular hours but work all year, it's still important for them to take some time off. So this applies to leave years starting from 1st of April, as I've said. It applies only to irregular hours and part-year workers. Andrea's already given us a definition of those. Many will remember paying for holiday entitlement in this way previously, but in 2006, the European Court of Justice made the practice unlawful due to concerns that workers may not take time off work for rest because they could earn more by keep working. So it's as we say, it's important to make sure that your employees take a break even if their holiday pay is rolled up. And so yes, so now, as we've said, you've got a choice now whether to do that, whether to go down that route, choice whether to reintroduce this method, or carry on as you are.
Okay, so one question I've got to begin with is, if your holiday year started in January, so remembering that the option to use 12.07% and rolled up holiday pay is from the 1st of April 2024, or leave year starting thereafter. So if you're already in a leave year that started on the 1st of January, what's the situation there?
So it applies to leave years that started from the 1st of April. So leave years, if you're in a leave year which started in January, for example, as you say, Ed, then this won't apply until next January. Yeah.
Okay. So now if this is relevant, I don't want to disappear down a rabbit hole here, because because this is something this is something we did talk about over the last few days internally, about if you were in this situation where you were in a holiday year already, so you'd missed the April the 1st date, or you'd already started your holiday year by then, but you wanted to use rolled up holiday pay and 12.07%, did you have an option other than waiting until the beginning of your next holiday year? And from what we could see, there is an option to start a new holiday year for those people in that category. So we're working on the basis that most organizations, not all, but most, have probably only got a small number of this type of worker. You could isolate those types of workers and agree with them that you're going to start again on a new date and then apply these methods to them over a new holiday year. So Andrea's got yes, Andrea.
Sorry, I'll just chip in very, very quickly.
Yeah.
Just a little health warning.
Yeah.
Ed is entirely correct. You can effectively, it's not even yes, you agree, you always consult and explain what's going on, but what you're effectively saying is we're going to change your holiday year. You people, you've got this arrangement, and you've got these irregular hours. We're going to be, and we're doing it to comply with and to bring you in line with the new legislation. So as with all of these things, it's presentational and how you're communicating, and what you're saying is, so the law's changed. We've got it aligned and simplified, ideally, apparently. So we bring you in line with that, and in order to do so effectively, we're going to be switching your leave year and aligning it to that. So
we did think that for many people working variable hours, actually a rolled up holiday pay is quite attractive. So that you might find that there is a willingness to make that move, particularly if you're doing very variable hours. So you do have plenty of periods when you're not, when you're not working. Anyway.
Although we did have the joys of the Harper and Brazell case, which did mean that some people who were working over the summer, if they had a continuing contract, were finding that they were having more holiday available to the natural time that they were working. And one of the reasons why this legislation was brought in was to avoid that scenario, which was patently unfair. So
okay. So if anyone's of a mind to not wait until their next regular holiday year, I think the point there is take some advice about how you might do that, because there are definite pros and cons in it. Okay. So the other thing I just wanted to clarify on the rolled up holiday pay is that effectively you are paying it in respect of each pay period. So in effect, what you're doing, and again, I stand to be corrected by anyone on the panel, is if you're paying people monthly, you look at what they've worked in that month, you calculate the entitlement that they have in that month, and you effectively pay for it in that month. Would I be correct?
Yes, Ed, you are correct.
Thank you.
So yes, you have to pay for the holiday within the pay period that it has been accrued, and you have to itemize the holiday pay on the pay slip.
So that's in relation to the rolled up holiday pay.
Rolled up holiday pay,
The rolled up holiday pay, effectively, it's an uplift of 12.07% to their pay for the work done in each pay period. That's for the rolled up scenario. If you're paying holiday pay when the holiday is taken, it's a different.
It's a different, and we'll come on to that.
Come to that later. Sorry to interrupt, Ed. There's a relevant question to that calculation, which I think we should just quickly answer. So the 12.07%, you'll remember Andrea's slide showed how that was calculated. And somebody's just asked, Ryan, thanks for the question, asked how do we run the calculations if we actually have more days? So very simply, that calculation is based on 28 days out of a full 52-week year. And you'll remember the calculation was essentially dividing the number of working weeks. If you end up, let's say very simply, you've got 30 days instead of 28, you simply adjust the calculation. So your start point is then not 5.6 weeks, it's 6. And then you use the remaining weeks of the year that are left to divide it by. So you'll remember in the original calculation, it was 42 point something. Well, if you're then taking the 6 weeks of holiday per year, then you only have the remaining balance of the year to divide it by. And that will give you a slightly different percentage. So your percentage will end up being 13 point something. So if you have more days as your standard holiday, you redo your calculation to get the right percentage for your holiday allowance.
Yeah, exactly. If you're paying your full-time staff a contractual holiday that exceeds that 5.6 week statutory minimum, you're going to need to look at increasing the percentage for the rolled up holiday pay. But otherwise, effectively, you're breaching their right to a pro rata entitlement. So you've got to make sure that they are aligned to what full-timers are getting.
Yeah.
Excellent. Thank you very much. So whilst on the subject of pay then, let's look at what a week's pay is, because essentially this gets to the elements of pay that you need to include in holiday pay. Okay, so and there is clarification in the law in the recent changes about what has to be included in holiday pay. So Chris, I think am I coming back to you for this?
Yes, you are. Thanks, Ed. Yes, so with actually definition of what's included, what additional elements are included in a week's pay when you take this into account. So first of all is commission. If it's intrinsically, I knew I'd get that wrong, linked to a worker's performance. So a bonus or commission that's paid based on the whole company's performance isn't intrinsically linked to the worker's own performance. That's a general one. It's if it's commission they would earn if they were operating in the business. It includes payments for professional or personal status. So someone might get an additional allowance paid to them because they hold a particular license, I don't know, like an alcohol license, for example, and that would be included because they're still holding that license. Any overtime that's regularly paid in the preceding 52 weeks. So a one-off element of overtime wouldn't be included, but if somebody regularly worked overtime, then you need to take that into account. And overall, these elements and so this sort of definition of a week's pay actually only applies to 4 weeks out of the 5.6 weeks statutory leave. It doesn't apply to the remaining 1.6 weeks, incidentally, although in practice, most employers just apply it to the whole 5.6 weeks. Is too complicated to separate the two out. So there you have your statutory definition of a week's pay.
Thanks, Chris. And people will be appreciating that there are a number of grey areas in this. So one that we often get involved with, for example, is when is a bonus included and when is it not included, which gets to the heart of this question of, is it intrinsically linked to a worker's performance? One of the tips we're going to have for you at the end is to make an assessment of and get advice if necessary on what, whether your different pay elements are to be included in the calculation of holiday pay or not, because some of it is a bit grey. I don't know whether anybody else has got any comments to make on that before I move on, or whether there are any questions that anyone has who's listening about those pay elements. Yeah. Oh, you've put yourself back on mute, Andrew.
Right.
Oh,
Okay.
right.
I would only say, I think somebody's put in Q&A, you know, what's regular overtime, what's regular
Yeah.
there will continue to be debates, arguments, and cases around this. You know, and we always get really unhelpful definitions like, you know, more than occasional, which is not helpful. So, you know, realistically, you know, regular overtime is, you know, I can't give you a definitive, but it will be, you know, an expectation that, you know, that within a pay period there is some regularity of overtime being paid, not and if it's also if it's enshrined within the contract or in some contractual documentation, so much the better from the employee's point of view, because obviously the expectation is it's not just the odd, oh, we need you to do an extra couple of hours, we'll pay you for it, and it's not enshrined anywhere, and it's happening once every 6 months or not even that. Commission as well, is, you know, like you say, is it intrinsically linked to the performance of their duties? We've very recently had a case to do with cabin crew, BA cabin crew, about meal allowances, and because BA couldn't show that this was, you know, covering occasional or ancillary costs, that it was intrinsically linked to the performance of their duties. You know, they looked at all the relevant facts and the circumstances. You know, is it expenses? Is it performance related? And again, there's, you know, it's going on the Plumbing Appeal Tribunal and beyond, because for this very reason, it's not always clear cut. So look at your contract, look at historically how often this has come up, how often it's been paid, what the expectation is. If you can get some advice, and just sense check it as well.
Yeah. Okay. No, that's really great.
I think I'll just chip in as well there, Andrew, because I think that's really true. And I think from a practical point of view, we always go back to the point of these regulations, which is that the employee shouldn't be worse off when they take holiday. So from a practical standpoint, when we've looked at this with clients, we've looked at the pattern of pay over the previous year. We've looked to see if during periods of we've looked to see how regularly these additional payments are made. And then secondly, we've looked at the impact of holiday. Essentially, that should be a relatively smooth pattern. There shouldn't be a dramatic dip where the employee is substantially worse off during a period of holiday than they normally are. That's the general principle.
Yeah, it's a good rule of thumb. So the other thing that's mentioned there is about looking back over 52 weeks, and it's with some trepidation that I raise this as an issue, because an assessment, because we're not now just talking about the irregular workers and part-year workers, we're talking about everybody in terms of that assessment that needs to be made for what you pay as holiday pay. And so let me see if I get this right. And again, the panel can correct me. So if you've got variable workers and you're using the rolled up holiday pay method, you're just going to look at those pay elements for the month in which, or sorry, for the pay period, normally a month, in which you are rolling up the holiday pay. So if you're rolling up holiday pay for a variable hours worker, you're going to look at, in that same month, you're going to look at what their applicable, you know, what their basic pay and any applicable commission and other things, and use that to calculate the pay that they receive when you roll it up and add it to their pay slip. For everyone else, it's basically looking at that 52-week average where you are. So when you're paying, when people are applying and taking their holiday, the holiday pay there is essentially an assessment over 52 weeks of the averages of those various applicable pay elements.
Agreed.
Okay.
Yeah.
Good.
Yeah, so that is essentially that, because the rolled up holiday pay is the 12.07%
Yeah.
of their pay for the work done in each pay period. So
Yeah.
whatever pay period is, you're giving them a top up of 12.07% of pay for the work done for that period. For when you're paying it when it's taken, you have to go back the previous 52 weeks to get an average amount of weekly pay over that 52 week. 52 weeks. And the question that's often asked is, I mean, that's 52 working weeks. And obviously,
Yeah.
they're not necessarily going to have worked over the past 52 weeks. So you have to go back further to try and get 52 working weeks. If they have only not, joined you sooner than that, and you can only work with what you have available in terms of preceding weeks.
Yeah, and you can go back, but the maximum you'd have to go back would be the 104 weeks, but that's the absolute maximum. But you're essentially looking for 52 working weeks when they earn money.
Yeah.
Yeah.
Okay. Fine. Any questions, Sandra, before we move on to the next piece? We're going to look at the carryover rules.
Yes, we do have quite a few questions actually. So
Okay.
I'll start with this one. Do holiday entitlements have to be taken, or can they be paid? And if they are paid, can the employee come back and say they are stressed because effectively they've worked 52 weeks in the year?
Oh, what a great question that is. That is a perfect thank you, whoever asked that one.
Well, what we're talking about here is part year and irregular hours workers. So effectively, they're not full timers, so they're not ever going to be working 52 weeks in the year. So, if that's what you're looking at, and you have, what you're making sure here is that they are being paid because they are part year or irregular hours. They are making sure that their pay does include an element. And it very much, depends. That if they're taking the holiday, fine, but it depends on what the working pattern is as to how that works. And a lot of people on 0 hours, they just want wrapped up in their pay. They're doing 0 hours, so they're in and out as and when needed. So
yeah,
I think sorry,
Karen.
Karen.
No, sorry, Ed.
No,
I was
you
going
go.
to say I'd add to that. The answer to the first part of the question is absolutely yes. For these types of workers, you can roll up the holiday pay. So that's what we've got back. So the answer to the first part of the question is, if it's that type of worker, yes, you can roll up the holiday pay. In answer to the what if they work every week of the year and they're completely stressed, that's really the point that Chris was making earlier. It's still your responsibility as an employer to be aware of their working hours, and everybody, all workers are meant to take no less than 4 weeks off in any year. Now, part of the reason that rolled up holiday pay was removed was because of this concern that people would essentially keep working, potentially in more than one job, and maximize their pay. But you as an employer have to do the best that you can to make sure that they are taking time away. So yes, you can roll up the holiday pay. Because they're irregular and part year, you've got a really good chance that they're getting sufficient rest anyway, because you are not contracting them full time. But you do still need to keep an eye on their time off and make sure they meet the minimum. I think that's the best way to reply to that one.
Yeah, that's great. Perfect answer. And as we'll see a bit later when we come to what should you do differently maybe going forward, that kind of monitoring, I think, of where people are with their holidays is going to be a bigger feature, I think, that you keep more of an eye on it over the year for a couple of reasons, actually, not just that one, but then we'll come to that towards the end.
Yeah.
So Karen, let's stick with you because the next topic is about holiday.
I don't think we've done all the questions, Ed.
Oh, sorry.
Yeah, I think there's a few. If they
Sandra.
fall into this previous topic, Sandra,
Yeah.
Could we do any others that are relevant?
Yeah. So this question is about benefits in kind. If they're payrolled, would they form part of the week/month's pay?
I think the answer to that is, generally speaking, no.
I want to say no.
Yeah.
I kind of feel like I need I need an expert. I want to say no.
Yeah, it benefits per se. I mean, some benefits can form part of pay, but on the most part, they normally
They're
don't.
not pay.
So,
Yeah.
yeah,
We're talking pay here rather than
but we're
non-pay
talking-
items.
So again, we're back to what is it for? Is it linked to the performance of duties, which is exactly what came up with the BA case with a meal allowance? And is it as an expense, or is it part for, you know, do they have to have it to perform their duties? So, or is it just a nice to have add-on benefit? Ordinarily, it's a nice to have add-on benefit, and no, you wouldn't be including it as part of that calculation.
Yeah, okay.
Perfect, thank you. Anything else, Sandra?
Yeah, I'm just going to mention one last question for this section.
Okay.
How do you prepare the calculation for a new employee as you don't have any prior data to base it on?
Another great question.
Yeah, I mean, again, you would have what their allowance is, whether it's statutory or whether they have a contractual. So their contract would provide what their pro rata holiday entitlement would be. The data that you don't have, obviously, is going back. Ordinarily, they wouldn't be taking holiday on day one. If they are doing, you just have to base it on basic pay, what's expected their basic pay would be. You can only work with the information that you have got. So you just have to look at the timing of the holiday and what the contract provides. If there is the data, then yes, otherwise you have to use the anticipated for any holiday. But lucky them if they're taking their holiday as soon as they walk through the door.
Yeah, I was going to say, if you're kind of 0 hours or an irregular worker, you won't have accrued anything yet.
Yeah.
So I think if you asked for any holiday within your first month, the answer would be no. But I think when you employ somebody on a contracted basis, you take their annual holiday and you can proportion it for the year, so you know what they're going to get. Whether you then choose to grant that in advance as of day one is probably dependent on your contract and how you manage it. But people do need to accrue holiday to take it.
Just spotted we've had a question about carryover, which is timely.
Yeah, that's
Perfect.
coming up. So yeah.
Okay, well, let's go there then. And Karen, you're going to pick this one up. So the final area that was covered in the legislative changes was some clarification on holiday carryover provisions. And here again, we're not just talking about irregular workers anymore. Well, this is applicable to everybody. Yes.
Yeah. Okay. And we have had a few questions come in on this. So what was meant to be a clarification has sometimes caused a little bit of confusion. So yes, just to look at the key points that we've got here. So let me just set the base point. I'm talking about a minimum statutory holiday entitlement, which is 5.6 weeks. That is a week for whatever the hours are for the worker. So for a full-time worker, 5.6 weeks is 28 days. Now, as Andrea said earlier, how you choose to allow those days to be taken will be part of your working arrangements and your contract. So let's say you're in a normal office environment, you probably allow 4 weeks to be taken whenever the employee wants it, and you'll have 8 bank holidays where the office closes, and they are then automatically holiday. If you're in a retail environment and you're open every day, you'll probably give your employees 28 days to use as and when, and they'll work on the bank holidays as a normal working day. So that's the parameter. Now, in terms of carryover, we said earlier that all workers should take no less than 4 weeks away from work for rest and are entitled to those 4 weeks paid holiday. So when we talk about a maximum of 8 days being allowed to be carried over, that's because that's essentially what's on top of that. So if an employee has taken their 4 weeks of holiday, then it could be possible they've got 8 to carry over, and that would still be within the regulations. However, if you have a holiday policy or you have a contract of employment that says something else, these regulations don't change that. That seems to be the confusion that we've had. You don't need to change anything. This is purely stating what the situation should be, and what is the potential carryover. So provided people have taken no less than 4 weeks, if they get holiday entitlement in excess of that, they could carry that over. And if you don't define it anywhere, then they can ask to take it over. But if your contract says you can't carry over any, or you can only carry over 5, or you can carry over 5 and they need to be used by March the following year, all of that will still apply. And there's no change to that. They can't come to you and say, I don't want to just carry 5, I want to carry 8. That doesn't change. So 8 days with the agreement of the employer. If you happen to have something like 30 odd days holiday, then there's more potential for carryover. The second thing is also something we've been dealing with for a long time. You'll be very familiar that those who take statutory leave, such as maternity, retain their full holiday entitlement for the time that they are away, and you cannot restrict their carryover. They carry over the full amount into their into the period when they return if they didn't take it before their maternity or other statutory leave. So we continue to allow them to carry over in the way that they have. Similarly, with long periods of sickness, employees continue to accrue their holiday. They also are allowed to carry that over because they haven't had the opportunity to take it, but there is a restriction that they must take that within the 18 months of their return in that new leave period. So if they don't take it within that time, they will lose it, but they can carry it over. That actually isn't new. The bits I really want to talk about are the next two, because they are new and they are going to affect the kind of diligence with which you communicate and manage your holiday. So the first thing that is new is that if an employer fails to recognise the right for a worker to take paid holiday, or they don't give them a reasonable opportunity to take that holiday, then the employee will be entitled to carry it over, the full amount that they've been unable to take. And if you fail to warn them that they're going to lose it, equally they'll be able to carry it over. So those two things are really important. We haven't had that clarified in regulations before, and it's going to mean that in either of those situations, your recording and management of holiday is going to need to be really spot on to prevent either of those things happening.
Okay, thank you, Karen. So do we have any other questions on carryover that we can answer?
One question, do you have to remind employees on a regular basis that holidays need to be taken?
Yeah, that is a perfectly timed question because I will talk about that next. So the answer to that is absolutely yes. You may not have kind of thought that was perhaps your responsibility before. You might have said your employees should manage their holiday through the year, but they have been given some additional ability to put the onus on the employer to say, I couldn't take it, so now I don't want to lose it, and you can't take it away from me, so I'll carry it over. So let's be a little bit careful here. I'll cover that in the practical tips that we're just finishing up with here. So the first one we would say is check your leave dates. So we've said that these regulations start for holiday years from the 1st of April. So is that you? And do you want to make any changes? If it isn't you and you're already within a holiday year that is up and running, you can get prepared for next January or whenever your leave year starts to implement these changes. So the second point we would say is check your contracts and handbooks. Check what you say about holiday in your contract, particularly anything to do with use it and lose it. And check that your policies are explicit, and check that you make it really clear what happens if employees don't use their holiday within the holiday year. If you don't allow employees to carry over, that needs to be specified. Coming on to the point that was just raised in terms of, do I need to tell them? We would really recommend that you accurately track your holidays. We're always big fans of HR systems. We always give them a shout out here. Track your holidays accurately in an HR system that the employee has access to. It's then their responsibility to apply for holiday, and they can view their balance throughout the year. You can equally run reports that show holiday usage, and you can identify those that aren't taking their holiday, which is accumulating in a way that's going to be difficult to use before the end of the year. And you can communicate to them to encourage them to balance their leave usage through the year and ensure that they're then given the opportunity to do so. The last thing you want is to run into let's say a retail busy period at Christmas and find that you have employees who are trying to use holiday before the 31st of December. Obviously, they haven't done their side of it in planning it out, but you could have been sending out reminders through the year to say that you weren't going to be granting holiday in December. So they needed to be better organised on that. I would also say that, be really explicit about use it or lose it and send that out, and be really clear when holidays are refused and the reasons why. You're going to be able to want to track back on that. If you end up with an employee saying, I want to carry over, and you don't believe that they've managed the situation properly, you're going to want to show why those holidays were refused but can't be carried. So I think record keeping is really important there. And then our final practical tip is obviously review your holiday pay. So if you have irregular hours and part-year workers, you can choose your approach for those workers. And for anybody who, for any holiday pay that you're calculating where you have additional amounts coming into that week's pay, check whether they now need to be incorporated into your calculations to pay your holiday pay correctly.
Okay, thanks, Karen. I appreciate we're running a little bit over time, but I'm sensing that people are finding this quite useful. So, and there are some remaining questions. So let's take a couple of minutes just to see how many of these remaining questions we can get through. If people still have questions, please still add them on. If we do run out of time for them, we will definitely come back on them separately. So Sandra, let's see what else we have.
Yep, so we've got a question from Fran. Could you backdate the holiday year to the 1st of April if you need to consult now in May and restart from the 1st of April?
I'm going to jump in and say that it's much harder now. You're in the year. It's much you can, because it's for holiday years that start from the 1st of April. I'm guessing you haven't talked to your employees or thought about that yet. I guess the answer is yes. If you talk to them now and gain their agreement and understanding and make the changes, then you can then take account of anything that's happened in April and put that in place from the 1st of May. So that is still possible, yes.
Yeah, it's a bit unclear about the backdating position. It wasn't envisaged. All the reference has been around what happens now and going forward, and from the 1st of April. So, but I would say with all of these things, if you talk through, explain the rationale and get agreement and document it, then, the only people who are ever going to challenge it are the employees themselves. So, you've just got to make sure that it works for you practically and it works for them practically, and everybody knows what the position is and it's documented.
Yeah.
Thank you.
Thank you. So the next question is, are full-time UK employees receive 25 days of annual leave plus the 8 paid bank holidays? So when an employee leaves, they calculate the leave owing based on the 25 days entitlement, but should they actually be doing this calculation on 28 days?
No, you would calculate any leave owing on their contractual entitlement.
Perfect, thanks, Karen. Where staff contracted hours but irregular shift patterns and paid monthly, how do you practically calculate weekly pay as payroll is run every month?
So again, we're into those, how are we paying them scenario? Are we doing it on the rolled up basis? In which case we're working out the 12.07% at the end of each pay period, at the end of the month. If we're doing it as we pay them when they're taking holiday, we're looking back over that 52-week reference period. So it's opting for one of those two options. And then you are effectively either using working out what the average hours are, like on the calculations that we worked through at the beginning. You're either doing it based on the 52-week reference period or the 12.07% of hours worked in that pay period in the month.
So just to clarify there, so if your pay period is a month, and you're doing rolled up holiday pay, you don't need to worry about weeks. You're just going to roll it up for that month.
Yeah, you're just going to look at the average. Yeah.
Thank you.
Okay, so just following on from that question, it's about rolled up holiday pay again. So this person has asked, it's paid throughout the whole year. So if the employee is new, and although they haven't accrued holiday yet, at what point do you increase their pay to the rolled up pay to include the holiday?
Well, that rolled up element is in their pay throughout, because you're literally just giving them an uplift to their salary based on the 12.07%. So their first pay packet will have an additional 12.07% of the average hours that they've worked in that first month tacked on to their pay for that month. So it's accruing that additional element of pay is right from the word go, and will be in their first pay packet and then calculated as you go along
with any other element of pay that is included in holiday pay. So if there was commission in that month, if there was other things, then that would be based that calculation on that full amount.
I think it's the pay period. So they may have just started work, so they work the first week. At the end of the first week, if you're paying weekly, you'd pay them a week's pay plus 12.07. They've just joined you, they work the first month, they get their first pay packet at the end of the month plus 12.07. So it's every single pay period you would top up the holiday.
So just a reminder on that, then, if you're using rolled up holiday pay, you're not going back 52 weeks for an average, you're just doing it based on the pay that they've received in that pay period. Yeah. Okay,
we've had a question from Victoria. Just to be clear, carryover of up to 8 days only allowed with employer's agreement?
Yes. I don't want you to get to the end of the leave year and then say what your agreement is, though. I want you to I want you to be really clear. So you get an employee gets a written contract of employment on day one, on or before day one. In it, you will have your holiday entitlement, the arrangements for taking holiday, and your rules on carryover. And then they'll join. You'll have a holiday policy with a bit more information, and that will confirm your carryover policy as well. So yes, you can say what you like about the carryover, whether you want to give them 8 days or give them none, but you need to make it explicit.
And there's a question about deductions as well here about overpaid holiday pay, which it's kind of the same answer, which is you need a deductions clause in your employment contract to make it clear that any overpayments or such like you can deduct, because it is correct, as the attendees said, that it is, you can't make deductions without, well, it's not so much that they're explicitly signing a letter saying I consent, but their contract needs to provide that you are able to make deductions, such in relation to overpayments or etc. So
we always work with clients when employees leave to work out the holiday taken in that year of leaving, because it's going to be a part year, and the employment contract should say that you can get paid for the accrued leave if you've not taken it, but it could be deducted if you've overtaken it. And Sandra, I think I just saw a question. Was there one about paying for unused holiday? Could I just answer that at the same time?
Yeah, so it's, if people do not carry over days, can they be paid for them?
No. So you shouldn't be paying for holiday within employment. You should manage the carryover, and they should be allowed to take it. You only pay for unused entitlement when the employee leaves.
Okay.
We've still got quite a few to go, Ed. I don't know whether you
Have
want
we?
to try to.
Yeah, I hadn't seen those.
Somebody's asking, can all employees see each other's holiday usage? No, an HR, I don't know how you manage your holiday, but on an HR system, it's the manager who can see the holiday allowances and what's taken within their team.
Can I chip in there, Karen?
Yeah, please.
Yeah,
you're
absolutely right. Usually on an HR system, it's the manager who has oversight, but you'll find a lot of HR systems also allow a team calendar, or a department. So an employee might be able to look and see who else is off in a particular week and see whether it's worth them trying to take the week off as well. But they don't usually see balances. You're right. That's usually for the individual and for the manager only.
Yeah, okay, that's really handy, thanks.
Okay, well, people are still with us, so I'm taking from that they wanted to carry on answering the question. So carry on, Sandra.
Okay, so a question from Peter: would the 52-week calculation of overtime be in money terms or hours? Our staff have recently had a large hourly pay rise, so this would make a difference.
I'm just thinking about the question as to whether I understand.
We're talking about the 52-week reference period. So obviously to work out what average pay is. So if they've had a pay rise, then their remuneration, again, their holiday or their average weekly pay should reflect what they are being paid when they are working. So if they have had a pay rise, then yes, some of those weeks will be at the higher rate of pay, and that will all plug into what the average weekly figure works out at.
Yeah, I think that. I see what you mean, Andrea. I think that the other thing there, though, is because you're taking an average of the 52 weeks, your holiday pay isn't necessarily your current pay, which if you just had a pay rise is higher.
Yeah.
Your holiday pay is the average.
But if you're paying them on the, because they are paid in this way, and you have the requirement to do the 52-week reference period, yeah, there will be, it will work itself through, but ultimately, they will be getting it in the same way that they'll have had different, because the fact is we've got variable pay over a period of time, and we're looking for an average.
Yeah. So the pay rise that Peter was talking about will come into the average.
Yeah.
So you're going to factor that into the calculation, but it's not the set rate of pay. It's not just that. You're going back over the pay they've had for the year, some of it at the lower rate, some of it at the higher rate.
Yeah. Since people are now beginning to leave, can we just put up the poll question? So for those of you that are still here, just give this a little bit of thought and tell us about any subjects that you're particularly interested in or want us to follow up on, so that we can bear that in mind going forward, and we can either put things in place or contact you if you've got anything in particular that you need some information on. Is there any? Where are we at on questions? Is there any?
I think there was a question. There was a question in chat. How valid are clauses that if holiday is not taken, they cannot be carried over or have pay in lieu? I mean, clauses should be valid. You pay in lieu, as Karen said, on termination. You might have carryover. You might not have carryover. The point here is that the onus is on you as employer to encourage and provide ample opportunity for people to take their holiday. And if you are not doing so, then that may call into question you saying, I'm sorry, but we can't let you carry over. If the employee turns around and says, well, I had absolutely no opportunity to take my holiday, even if I wanted to. So.
Okay. Are we there? Because I'm not seeing all the questions.
Yeah, we don't have any more questions.
Okay, all right. Well, thank you very much, everyone. Thanks for staying with it, and Hope you found it useful. Just to say, for those of you still with us, do join our employers community. If you're not yet a member, it's free to join, and it's just where we put lots of useful information and recordings of things and questions and answers. We will send you the slides and a link to the video that will also be on the Menzies YouTube account. And we will be in touch again with you later in the year to catch up on some of those other changes that I mentioned at the beginning. But for now, I think we've had quite enough of it. And so I'm going to thank the panel for their preparation and delivery. Andrea, thank you in particular for joining us this morning. Very, very welcome addition to the panel. And yeah, you know where we are, most of you. If you don't, we're Menzies People Solutions. Look us up on the website, and we will talk to you again soon.
Thanks,
Have a good day.
Bye. Bye.